guns and money.
Good evening, Crime Talk aficionados.
Send lawyers.
My name is Scott Reich, and this is Crime Talk. This is our Tuesday night live program. Thanks for everyone for joining us. I want to thank you all. For those who are perhaps new to this is our Tuesday night live show. We do this every Tuesday night. We've been doing them for quite a while now. On Tuesday, 6 p.m. Mountain Time, both here on YouTube and Facebook, doing a simulcast, so to speak. And for those of you maybe who haven't been here before, my name is Scott Reich. I am a practicing criminal defense attorney. And what can I say? When it comes to criminal cases, I think I've seen it all, just about handle it all, although there's always something else out there. But I think after 28 years, I have a pretty good idea of what is going on and what to expect. And for the most part, I think we pretty much call it correctly. So we do our live show, and then we'll immediately follow this with our Patreon show. And the Patreon show, you can actually call in. So if you'd like to talk to me, and we'll answer everybody's questions at that time as well. So let's get to it. So yes, I said, I think I normally can basically call it, know what is going on. The one exception so far that I just cannot figure out, the one thing I cannot figure out is this Lori Vallow case. Okay. This is the most bizarre case that I have come across. And yes, the facts are weird. Okay. The original players were weird, but they seem to be normalizing just a little bit. But procedurally, I've never seen anything with so much secrecy involved in a case that involves the death of 3 people where there's been an indictment. Okay. For those of you who don't know, if you haven't heard about it, Lori Vallow, Vallow-Daybell, they're charged with conspiring to commit the murders of JJ and Ty Lee. That's Lori Vallow's 2 children. And then there's also another conspiracy to commit murder, which is for the death of Tammy Daybell, which was Chad Daybell's wife. She unfortunately passed away unexpectedly. No real autopsy was done. We still don't know the results of what the autopsy results were. But after originally the autopsy was not done, just basically said, oh, natural causes, healthy woman who apparently was trained to run a marathon or something like that, completely healthy, just one day dies. Don't worry, we don't need to know those silly answers. And then Chad and Lori run off to Hawaii like 7 days later, get married, those whirlwind romances, the way they are. And, at that time people start asking, hey, where are the kids? I think it was grandparents actually that started asking, like, where are the kids? Then the friends are, where are the kids? But Lori, not to be bothered with those minor pesky details of her children, said, let's run off to Hawaii and get married. And they got married. And then it was the whole case regarding the abandonment of children, which was enough to get Lori Vallow brought back. And then Chad Daybell was sitting there in his nice, crisp little shirt, white shirt, similar to one I have on. I think, though, his is short sleeve. And just sat back there and watched the proceedings. And at the time, Lori Vallow was represented by Mark Means, who was a gift to Crime Talk. No matter what this guy did, you knew it was going to be completely contrary to criminal law, criminal procedure. Why? Because he had never done a case of this nature. In fact, he'd never done a felony criminal case. He was a divorce lawyer, did some mediation, and then all of a sudden he's thrown into what ultimately turns out to be a death penalty case. But apparently from the last, thing he did was he's like, hey, you know what? Right before they appointed Mr. Archibald as counsel because he wasn't death penalty qualified, He's like, I'm going to raise this whole competency thing. And then so Lori Vallow gets, report that she's not competent to proceed. And, she goes down to the hospital, the state hospital, for some 8 months. And then she gets restored to competency. Okay. Competency is, for the most part, can you fog a mirror, right? You blow on it. Oh, you're competent for the most part. If you can say, hey, who's the judge? What are the roles of the judge? What's the role of the prosecutor? What is the role of the defense attorney? What are the elements? What are charges? Things like that makes one basically competent. And it took like 8 to 10 months for Lori Vallow to be restored to competency, which was kind of holding up the whole Chad Daybell case, because I was never really sure, does Chad Daybell want to go to trial or not? I mean, everything just gets delayed. And I've said this before. Some of the best successes that I've ever had in a homicide trial are when I say, you know what, fine. Arraignment's here. Let's enter a plea of not guilty. And in most jurisdiction, that's 6 months to go to trial. 6 months. Let's go. Let's do it. And prosecutors never think you're going to go. Okay. Now, I get it. It's a death penalty case. You need a little more time. And I've done a case that started off, they were going to go death. And, first thing you're thinking, oh, I got to do mitigation. Which is actually quite fun because you get to usually go travel, talk with family members, come up with anything you can to say, oh, look, poor little client is not he never stood a chance. And you present that to the district attorney and, you go from there. And I get it. So, Pryor needed some time, but, the case shouldn't have been stalled just because Lori Vallow's down there. She had never actually made it to the advisement or the arraignment on the case, but Chad Daybell had, but then he waived speedy trial and did it again. And so nothing's got done. So practice point, right? If you're going to go to trial on a homicide case and you think you can be ready, let's face it, but it's probably is not very complex. Not everybody knows all the facts, but we know what we've been able to glean, right? Alex Cox, the brother of Lori Vallow, who also wound up dead, because, these things happen, right? What are the odds of these coincidences, were not just coincidence? Okay. It just seems like everyone around Lori Vallow, or somebody she doesn't really like or want around, suddenly dies, right? We know she's charged with her death of her ex-husband. Charles, what's his last name? Whatever it is, down in Arizona, which will probably never, ever, see the light of day, in the sense it's been charged, but it's not like they're going to, swoop her up in Arizona and take her down to Arizona to try her. So Alex Cox, they conspired with unknown conspirators, both known and unknown to the grand jury. Well, if I was, Chad Daybell's attorney, what would I say? I have no idea what happened. The defense would be simple. Ladies and gentlemen, if you haven't noticed, she's crazy and her brother's crazy. Chad Daybell can say, hey, maybe I had some beliefs, but they weren't crazy beliefs like I'm a goddess and then I can detect, dark people, so to speak. But those two kind of did. They're crazy nuts. And whatever they did, that was on them. I had nothing to do with it. I am the victim here in this particular case. There you go. Chad Daybell's defense. Haven't needed 3 years. We're coming upon 3 years, ladies and gentlemen. So I ask you this. If I ask you this, the trial date is now set for January, I think 13th. First or second week in January of 2023. Do you think if nobody had waived speedy trial, do you think that the prosecution would have been ready to go? Hell, we're still fighting over if DNA can be tested. Remember, we have trial date. Here we are, and we have September, October, November, December. Now I get that. That may be an eternity in most worlds, but usually not when it is a death penalty case, right? You want to get all your witnesses lined up. You want to get everybody ready to go so that you have all of your witnesses. Do you really think the prosecution would be ready? Okay. Now, early on, Mark Means made a whole big deal about disqualifying the prosecution in this particular case. He basically said it was witness tampering based upon an interview that Mr. Wood had with, I think it was somebody in Lori Vallow's, was it? I think it was her sister or brother or something to that effect, where people are like, yeah, it's really hard because obviously we love Lori, but if she's done something wrong, we need to do it. And Wood is on the recording and we've played it. We've got it. You can look it up. Basically, he's saying, hey, I get it, but I think, obviously whatever she's done, she's got to pay for it. But, we think that Chad is probably the evil person here because he's really the one that exerted the influence and et cetera, that kind of stuff. And that the attorney then for Lori Vallow, Mark Means, made this big argument. It was that he was witness tampering investigation, start a whole investigation through attorney regulation. They held a hearing on it, blah, blah, blah. I mean, I was there thinking, if that's witness tampering, intimidation, I've seen a heck of a lot worse from DAs that I dealt with. I thought that was, no, it wasn't. He was down the road, acting as a prosecutor, kind of interviewing witnesses and explaining the process of what was going on. I didn't think he did anything inappropriate at all. Okay. And that's what we try to do here, is call it the way we see it, whether it's right or wrong. It doesn't matter. 99.9%, I have no dog in any of these fights. Okay. So we call it the way it is. One day I'm being accused of, being pro prosecution. The next day I'm being accused of, being, too pro defense. You drank the Kool-Aid, Scott, all that kind of good stuff. And it's the same case, right? My opinions change based upon new information. That's what attorneys do, right? There's like some cases we just can't talk about here on this channel because some people already made up their mind, and by God, we're not going to listen to that. We made up our minds. It doesn't matter if there's new information. Okay. I mean, as an attorney, you are always reevaluating your client's case based upon new information. We've all had cases as attorneys where you think, oh, this is going to be the greatest case ever. This is great. And then new stuff comes in and you're like, wow, that's not exactly the way my client told me it was. And then you talk to him like, oh yeah, that's maybe not exactly where it was. Yeah. So I don't understand why people, some people just get so focused. They've made up their mind. They only look for information that supports what they believe. And that's it. That is a not great way to go through life. Okay. Like I said, as an attorney, you're constantly evaluating your client's case. You are constantly evaluating new information. How does this help? Does it hurt? Do we have to fold them? Do we go to the mat? Right? That's what attorneys do. And we call it that way. I mean, there's some cases where like, like here I thought early on, like, oh, this is not good. But I can come up with a defense. Like, let's go do this thing. My thing would be get the client's consent. Hey, you know what? We could spend the next 2 years doing mitigation, but really what it boils down to is sometimes we got to just go try the case. You got to stop looking for that document. You got to stop looking for the perfect witness. You got to go try the case. Okay. And that's what I've always said was the kind of the difference between a litigator, which is usually like civil guys, right? They litigate. They're always on the hunt for this document and they're playing the gotcha game and they're going to get it, which is why I hate civil litigation, but we'll do it, for obscene hourly, pay. But it's just a game of everyone knows this case isn't going to go to trial. You litigate, and then they settle on the courthouse steps, right? Criminal stuff, like, we're going. Let's do this thing. I'll see you in court. I offered to see, for clients, hey, we're going to do this case. I mean, I talk to the DA. Is there going to be an offer? And they're like, the only thing, we're not going to make any offers. The only thing we're going to offer is a fair trial. Okay. And then, of course, the prosecutors come up. Hey, we got this whole little witness issue thing for getting in some records. Would you stipulate to that? Because it's really hard and it's expensive. We got to fly a witness in. It's going to take like 10 minutes. Yeah, that sounds like a real pain in the butt. But just like you guaranteed my client a fair trial, guess what I'm going to do? I'm going to wave the American flag because that's the only thing we're going to wave. I'm going to make you prove your case beyond a reasonable doubt to each and every element of the offense charged. And then maybe we'll see if you can get that evidence in. Good luck with that. Oh, yeah, and tell your boss the reason why, you're going to spend those $2,000 to fly that witness in for 5 minutes is because you were a jerk early on and you said, screw you. Okay, we can both play that game, right? So we digress. But what's the point here? I like the prosecution early on in the Valo case. I'm like, this Wood guy seems pretty straightforward. Seems like things going well. Don't really understand some of their charging decisions. But, they're the prosecution. And then as things went on, the prosecution, let's face it, they have pretty good odds against them. I mean, they're playing with house money. They get all the resources, right? Has anyone ever told the prosecutor, oh, we can't do this case, it's too expensive? No. As my old boss used to tell me back in the Marine Corps, there's always money for justice. They'll find the money. Heck, and in this case, they brought in somebody as a assistant district attorney out there to help Mr. Wood because she had death penalty experience. Now, it seems as though there may have been some issues with some of her cases, which, just saying. And frankly, what's his name? John Pryor filed a motion saying, hey, give me a list of all the cases that she's worked on, back in Missouri where she was working on this case. And the judge says, no, we don't have to do that. And frankly, I agree with him, the judge, in that. But hopefully, and it doesn't take much work these days to do it, Rachel Smith is the name, and she had Smith Law Consulting, okay, out of Missouri, where it looks like she was a former prosecutor, did a couple of death penalty cases, whatever. It shouldn't be that hard to find all the cases. And, if you got the resources, you start making phone calls. You have investigators start making phone calls. Or better yet, you go talk with people that they worked with. And I'm telling you, and I've said this once and I'll say it again, this is what most people forget. I think a lot of lawyers forget this stuff. Most cases are not going to be won or lost on the law. The law is what it is. And it's usually quite bad for the defense. What it comes down to is who can find the best facts, okay? The facts applied to the law makes the actual verdict, makes the ruling, whether it be on a motions hearing or ultimately a question of fact for the jury. A quick example. Have a case, let's just say some serious charges. And my investigator's been out looking for witnesses, and they've been, difficult to find, to say the least. And he finally tracks them down. He's like, hey, you want to go with me? I'm like, hey, I don't have to be in court. Let's go. I'll meet you out there. You give me the address. We get there. Not at this address. Change to new address. Got it. Go there. Fine. Talk to this witness and like, wow, this isn't really the witness that I was anticipating. And because all the bad things that were said about this particular witness by another particular witness. And I'm going through and, we're asking questions, and it's like, oh, this is getting good. This is getting good. And I finally said, you know what? This other person says that you did all these terrible things. And frankly, if what she says is true, you should probably be charged like my client with all these terrible things. And she looks at my investigator and she goes, none of that is true. That is completely fabricated. And I'm like, really? Well, has anyone ever, who else have you ever told this to? She's like, well, I told it to the federal agents that came to my house. It rhymed with FBI. I'm like, oh, okay. So I'm thinking, okay, well, that's funny because you told all this to them. You can describe where you went. You described kind of who was there, the room and all that kind of stuff. But it's funny. I don't have that little piece of paper in my file, right? And so it just shows, we talked about it a couple times, assume nothing, okay? And this is why it cracks me up oftentimes here. You just have to assume nothing. Because I know it's going to be hard to believe. Sometimes prosecutors are not completely above board. Sometimes federal agencies not exactly above board. Okay. So needless to say, when I go to court and we have a little hearing, guess what? We're going to ask about that little conversation that somebody just happened to not memorialize that. Ooh, and that's called exculpatory information, right? So you have to go investigate. And that's what I'm sure the defense is doing in all of these cases. You can say, well, hey, you wrote, they said this statement, so it's got to be true. That's not true. And then they say, I can prove it. I go, really? Can we get a copy of that? You betcha. So, and you're gonna say, oh, Scott, you're just defense attorney. You're just a defense attorney. You don't like the government, blah, 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 blah. No, I love my country. I absolutely do. It's the government that scares the hell out of me, okay? And that I don't trust. And for examples like I just gave, I've seen that all of my years as a criminal defense attorney, right? A couple years ago when the whole criminal justice system is blown up and everybody's like, oh my gosh, the system is so unfair. It's unjust. This isn't right. And you're thinking, I've been telling you people this stuff all along. This stuff goes on all the time. But now somebody takes a look at it and they say, oh, we got to care. We got to reform this stuff. And like most things the government does, they go from one extreme to the other, and they usually screw it up in the process instead of taking nice little gentle turns. And, you can't do it, right? It's analogous to when I was learning how to fly. I'm up there flying and the instructor's like, you need to turn here. Okay, you turn here. And you come around, you're coming around and you're doing it and whatever. And all of a sudden, you're like, oh, we're coming up on our heading. We need to, and you crank it and you roll. And it wasn't smooth. And my instructor looked at me, who was a very experienced guy, had like 30,000 hours in the airplane. This is like 20-something years ago. And he looks at me and he goes, have you ever started a bath or a shower? Well, of course I have. Who hasn't, right? He goes, when you turn the water on and you stick your hand in there and it's too hot or too cold, do you jerk the knob all the way completely to the other side, to get the extreme of the other? No, I don't. No. Well, what do you do? Well, I gently ease it. And as I get closer to the temperature I want, I kind of slow it down, right? I'm like, oh. So suddenly my turns and coming up on headings became much smoother than they had become. And it's kind of like what you see when these people make these policy changes. They're here, the water's getting too hot or too cold. And instead of gently easing it back, they just say, let's just destroy it, chop it off, turn the faucet, jerk it to the complete opposite side. And then they screw everything up even worse. So, yes. So should we trust the government in everything that they do? Then they come out with? No, I would say don't do that. And if you're one of those people that say, no matter what the government says, as long as it's my party that says it is good enough for me, it's as clean, it's pure as the driven snow. Whatever they say is the absolute truth. Oh, yeah, wouldn't do that. Okay, because they all lie. Okay, and prosecutors, police, federal agents are all human. They make mistakes. They get a little excited. They want to win too. And sometimes they play a little fast and loose with the rules. Okay. So going back to our point here, right? Do you think if Chad Daybell had entered a plea of not guilty and said, I demand my speedy trial, let's go, let's roll, do you think the state would have been ready? I think not. So here we are now, yet again. Okay. There was a hearing the other day, and this is what, and this goes back to the whole secrecy thing that we talked about. Why? Okay. I hate to say it. When you go to court and you're charged with the deaths, the homicides of 3 people, I'm sorry. You got a little public shame there. Yes, you're given the presumption of innocence, but what could be more embarrassing than that, right? You've been charged with the death of not 1, not 2, 3 people, and 2 of them are your own children. And you're worried about privacy? Ooh, it could be sensitive. Are you kidding me? Well, that's everything that's been going on in the Lori Vallow Chad Daybell case. It is ridiculous. Okay, we've talked about this. We, as citizens of the United States, and whether you're in Idaho or I'm here in Colorado, or if you're in Timbuktu and you want a copy of the court file, you should be able to access it. Now, before, you used to have to go and actually say, I'd like to, you got your little piece of paper and you put your name on it, and they put the little slip of paper in the file slip, and they pulled the file and they gave it to you, and you can go sit down at the table, and then you'd make a copy of it at the copier at, 25 cents a page. And now everything's pretty much online in most jurisdictions, but I should be allowed to go get that. And they had a very similar issue here in Colorado where a judge, if they thought, well, it's embarrassing, they're highly upstanding people, they're not like the rest of the riffraff out there, so we're going to close this so everybody can do it. And there were no real rules. It was just kind of a general, well, if the judge didn't feel like it, we're going to protect the privacy interests. I get it. But it used to be go in and pull up any file. Yeah, I want to get a file. Okay, what's your associated with the case? No, none whatsoever. Just curious about the case. Just would like to take a look at it. And they give you the file. Now you can't. Okay. Now most jurisdictions, you pay a fee, you get access to the file, and that's it. But they can track what you take. But it's become so ridiculous now where nobody can look at anything. Oh, it's too sensitive. Oh my God, it's so embarrassing. What could be more embarrassing when you're charged with 3 counts of homicide, please? And they're trying to kill you? What secrets could you possibly have that are already out there? Seriously, come on. But now one caveat, one exception to that is I get it. If there's medical information, it shouldn't be made public. I get it. So you redact that page. Okay. And now the world knows what a redaction looks like. You put it in Adobe. I think it's Adobe Pro or whatever it is. And you can redact, you used to do it the old fashioned way. They did the whole marker and photocopy it. Now you just put it in Adobe and it's super easy. And now the rest of the world knows what a redaction is. If somebody had asked probably 5 years ago, no one would know. Even a year ago, people are like, what's a redaction? Well, that's a fancy word for using a marker to block out stuff. Okay. They redacted it. You redact it. Take it out. Whatever. I get it. But everything else we should have access to. And here in the Lori Vallow Chad Daybell case, they're playing games. Okay. And we had Lori Hellis on. She's a retired attorney. She's a writer, I think, a member of the media, so to speak. She's got credentials, media credentials. And she's like, hey, Judge, I'd like to get a copy of this court file. And I have offered Lori any help that she needs on this. I'm like, I've got attorneys that can do research. What can I do? What can I do to help you? Because frankly, I sit here and complain about it, but I should have been doing something like Lori Hellis did. But we had her on a show. She's a great guest. We're going to have her back again. And she's been attending the court appearances, right? And so when I said, oh, there was something like, there was this whole conversation about the hearing that they had last week, and then the judge issued this order basically saying, we're not going to let anybody have access to the court file, right? Well, once again, they're playing games. Lori Hellis has called them out and say, Judge, you can't just blanketly seal, so let it be written, so let it be done. I am done. I'm, the scene in Moses where the Pharaoh says, that's the law. Now it's the law. This case is now sealed. Lori Hellis, she's an attorney, very smart lady. What does she do? She does what every attorney should do. Go to the law, look it up, and guess what? Hey, Judge Boyce, you're not following the law. You can't seal these unless you go through a certain procedure, and you haven't done that. And Lori Hellis says, and I want to be an interested party. But what does the good judge do? He's like, well, there's no such thing as an intervener in criminal courts. Oh, you're right, Judge. You're right. So just refer to her as the member of the public and then give her access to it. But no, what does he do? Form over substance. He says, Miss Hellis, please. If what's the word I'm looking for? And Laura, I don't think, she would say that when I've talked to her, she's basically said she's dealt with this all her life. Oh, you're a woman. Go sit down. Oh, just don't worry about it. The big boys will handle it, kind of thing. So she gets it, but she's ready. I think she had a post on Twitter the other day where she was like, let's party. Let's party, Judge Boyce. Ready to rumble? Let's do it. I'm paraphrasing her exact words, but it was something to that effect. And I'm like, good for her. And I was like, what else can I do? Anything I can do. Please let me help you. She's like, I got this. I'm like, good. And so it's my understanding, and I don't think I'm speaking out of school here, that maybe some things will refile, but no. More form over substance. And then the other day they have this hearing where, they're talking and all the parties are there. And then the court says that, they're going to have this hearing. We had a conference, everybody, and the defendant was there. And we were talking kind of about some competency issues. So he's like, I'm going to go ahead and, make an order that whatever we talked about on this date and the previous dates, if that wasn't already done, fine, it's good cause. So confidential, privacy, no one else can do it. And let me just tell you, okay? Let me just tell you what normally happens if somebody raises competency. On our competency statute here, and they're all very similar and the same, if the attorney has a good faith basis to raise competency, you can raise competency on the record, orally. You say, Judge, now you do usually ask to approach, and is it anything because you're particularly concerned about what's going on in the background? No. It's usually because your client doesn't want to be comped. They're like, no, I'm not crazy. Because it's always the crazy ones. They're like, I'm not crazy. People have been accusing me of being crazy all my life. I'm not crazy. So you say, Judge, may we approach? Like, Your Honor, I've got some serious concerns about competency. This is what I've seen. I think we're talking, voices, delusional stuff. I'm no expert, but I know crazy. All right. And the judge says, all right, good faith basis. Prosecution, everything say, no, Judge, he's had more contact with the defendant I have. So, all right, let's go back. Then the judge goes back and says, hey, defendant, there's been some stuff set up here, but it'll still be open to record. And based upon that, I'm going to give you a competency advisement here in open court. So everybody knows they're raising competency, and some people are thinking, well, are they going to bring out like a big suit with really long arms and they're going to wrap? No, it means they're just going to go and be evaluated. And if they're not competent, they're going to usually put them, on medication. That's usually what it requires. And they restore them to competency. And then they say, and then we're going to convict them. We're going to make you competent, and then we're going to convict you. Kind of like Lori Vallow. So that's just kind of where the whole process goes. But everybody in Idaho, and I don't get it. Maybe this is just something old school. Oh, we don't talk about these kinds of things. What goes on in our house stays in our house. Really? That's just crazy to me, because it's done in courtrooms every day. Now, sometimes the court will say, if you got, something, or you got medical records, file it, maybe file it under seal. I get that. But the gist of it is going to be done in the open court. It's not a big deal. All right? It's not a big deal. But here in Idaho, everything's a secret. Everything's a big secret. No, in the public, right? And here's the thing. It's a double-edged sword. I've had cases where there's been gag orders. Like, okay, fine. No one's going to talk. I'm not going to try my case in the media. And, there's been protective orders put out. Okay, fine. It used to be a protective order when there was something really big deal, right? Here's the proffer of the confidential informant that we truly believe that they're in danger. Okay, I sign under court order as an officer of the court that I will not present a copy to anyone other than on my legal team, and I promise to give that back. That's how you cover it. It's called a protective order, right? And now there is what's the word I'm looking for? It seems like every case I get these days, we want a protective order, Your Honor. We believe that our witnesses are in danger. Grave danger? Is there any other kind? No, the point is, it's like, come on, people. You've been watching too much TV. We talked about a case today where, the guy goes in and, kidnaps and does terrible things to his wife, attempts to kill her. But I know, you'd be surprised. There was a protective order in place. Oh, don't, like, that's going to stop somebody, right? Just like that piece of paper. And here's the thing. In most cases, like when it comes to protective orders, you don't want the snitch's name that my client already knows to get out to everybody. I mean, it's form over substance. Okay. Well, we're going to look like we're protecting everybody, right? And so the privacy stuff, I don't get it. They're going overboard. Judge Boyce, you need to let us know what the heck is going on. And I get the defense is there thinking, well, I kind of like this because the prosecution can't say anything because, the government has a tendency to leak things. Isn't that always funny how that stuff gets leaked, right? Nobody ever gets prosecuted for that on the prosecution side. When somebody leaks a document, I mean, we're not going to go off on other cases, but leaking documents, that's a crime in lots of cases. Could be a violation of court orders. Is anyone ever going to prosecute for that? No. But the defense, we need to make sure they're not trying to, try their case in the press. I haven't heard prior, even beforehand, that anything was being said. He's not giving interviews. Mark Means was just a little different, but I kind of miss him. I kind of like his spunk, so to speak, that he brought to the case. I think we need a little bit more of that Mark Means spunk now, just for some entertainment value, because I think it would really be fun. Now, he's been forever conflicted off the case, but anyway, we digress. The point is, we have a situation here where we have a right to know. The public has a right to know. There are motions out there regarding alleged prosecutorial misconduct. Now, I hate to say it, but most prosecutors, I mean, I remember when I was a prosecutor for a time, I was in the military, And the boss that was there, I was a major at the time. I was a young lieutenant. And he basically was like, you better get used to it. Okay. I said, get used to what, sir? He goes, well, you're a prosecutor now. Just get used to it. You're going to be accused of withholding evidence, destroying evidence, and fabrication of facts, to the court, because that's what you do. I'm joking. That's not what you do, but that's what you're going to be accused of doing. And I was like, oh, okay. I guess I can handle that. Like, I don't have any reason to hide anything, right? He goes, no. And my other boss was like, we'll give them whatever they want. And we're still going to convict their client. Okay. That has stuck with me throughout the years. Never, ever trust a prosecutor that wants to hide things, right? Think about all of these cases out there in the world that we all hear about where somebody's been on death row, or maybe not death row, but spending life in prison, and they proclaim their innocence. And guess what? Somebody rotates out of the office and people change, or somebody dies. And then they go through and they go through all the boxes and the files that have gone through, many, many times over the years. And then somebody pulls out the one document that they look at. It's like, oh, I guess we never turned that over to the, it says their client's innocent and there was somebody else who was there. Ooh, how did that not get turned over? Oops. Was that intentional? One could possibly argue, right? I can think of one or two times I've ever heard of a prosecutor being prosecuted for such a thing. It just doesn't happen that often. I think one case where somebody was, the judge was quite upset that evidence was being withheld. It was in the possession of the prosecution. And I think they got a grievance out of it. But I guess my point is what does the prosecution have to hide? I mean, I get you're not going to release all of the discovery in the case now, but we should be able to have access to the motions. And through the motions, we can find out facts that take place. Just like I tried to deduce, and maybe we'll have a better idea tomorrow. Is Lori Vallow not competent again? They had a little bench conference, and it was in regards to the statute the court referenced regarding competency. There's a hearing scheduled tomorrow. But guess what? It's closed to everybody. Don't worry. Don't worry. The government will tell you what you are entitled to, what you should know. Don't you worry your pretty little heads a thing about it. They're going to let you know exactly what you need to know because you just couldn't handle it. We're talking about sensitive stuff. And you start talking about sensitive stuff, and then people start getting emotional. And next thing you know, they're going to want to see the evidence, and they're going to want to show up for trial. Oh, we can't have that, right? No, you just trust us. Hint, hint, wink. Yeah, no. That's why what Lori Hellis is doing is trying to get access to these records and saying, Judge, you did not seal these documents properly. You did not have a hearing. You did not consider what an intervener is, even though interveners don't exist in Idaho law. Well, guess what? The term doesn't exist when it comes to federal law either. But what did the magistrate call the press when they said, release the affidavit in Mar-a-Lago? Oh, they're an intervener. Of course they are. But it goes back to form over substance. Judge Boyce appears to be doing everything he can to keep Lori Hellis from having her motions heard and ruled upon, and the court having to take a look at whether what Judge Boyce did was appropriate or maybe not inappropriate. And now the fact that he sua sponte goes back and says, sua sponte means on his own motion. The court finds the defendant's motion requesting permission to appeal two of the court's order filed on July 6th, pursuant to the Idaho Administrative Rules 12, was filed under seal and relates to the defendant's prior motions, including motions to disqualify, motions disqualifying prosecuting attorneys, state prosecutors, out-of-state prosecutor, motion to dismiss special prosecutor, and motion for disclosure of Rachel Smith's case were previously filed on seal, as well as the state's prior objections. The state's current objection to defense motion for a permissive appeal addresses the same issues are in a highly personal in nature, combined in the potential for unduly prejudice. What is unduly prejudicial? You're saying the prosecutors did something wrong. All right. Mark Means said that early on in this case as it relates to Mr. Wood. What did we do? We listened to the tape that was apparently the basis for the alleged misconduct. I sat there and said, I don't think Mr. Wood did anything wrong. And it ultimately turned out it was not. After they did all the big hearing, they did everything they were supposed to do. Okay. So why can't we take a look at that now and see what the issues are so that we can decide? It was a high profile case. 3 people were allegedly murdered. 2 minors. And they're worried about somebody saying, and remember, and I don't know what Mr. Pryor says, but I take him as an officer of the court, that he has a good faith basis for raising these issues. Okay. Attorneys can't just file. I know everybody thinks attorneys can do whatever and they file crap. No, you can't. You have to have a good faith basis for it. You have to investigate it. And if frankly, if you don't think it's true, you can't go forward on it. So I take John Pryor at his word as an officer of this court, an officer of the court there, that he has a good faith basis. And he is making a good faith claim, good basis claim, that the judge, or I'm sorry, the prosecutors have done something where they should be removed, or for some reason they don't qualify legally to be doing what they're doing, then guess what? How is that of a highly personal nature? Are you kidding me? The defense is saying, hey, he's not doing his job. Shouldn't the people of Idaho know whether their prosecutors are doing their job or if they did it correctly or incorrectly? That's why this gets me so fired up, okay? Because they think we're so stupid we can't figure something like this out for ourselves. We can't think for ourselves. We don't want to embarrass our people. We got to work with these people every day. And if it's embarrassing, oh my goodness. If you've been a litigator, if you've ever been a litigator, you've been accused of crossing the line somewhere in your life. Okay. Oh, you did this. You did this. It happens. You push the limits, but you don't try to, you kind of brush up against the line, but you don't cross them. And I don't know, if somebody did something wrong, somebody needs to know. Maybe it's completely frivolous, right? And if it's completely frivolous, remember like when I thought Mark Means made an allegation that Robert Wood had done something, it's witness tampering and all that. That's not witness tampering. Get over it. Like, seriously. And his credibility went down when it came to me thinking that he knew what the heck he was doing, right? So, like I said, if somebody is making these allegations and they turn out to be true, then maybe on the credibility scale, it'll go up, and vice versa. It'll go down for the party if they've done something wrong. How is that prejudicial? How is that going to affect somebody's right to a fair trial? It's not. Why? Because the only thing that matters, it doesn't matter what takes place in the court of public opinion. The only thing that matters is what is presented in a court of law, and it is admitted into evidence with legal and competent evidence. That's it. Okay? That's it. That's why everyone's like, oh, we got to get a fair trial. Okay, move the trial. I get it. Small townville, been there, done that. Get it out of there. You want to take it to a bigger city where you'll be surprised someone will never have heard of Lori Vallow and Chad Daybell, or think, oh, I heard something about a missing kid or something. You'd be surprised. So many people live under the rocks, right? We follow this stuff on a daily basis. This is what we do. This is what our interest is, right? Some people just don't care. I know people that I swear haven't watched the evening news or read a newspaper. If it didn't go by their Facebook scroll, that's where they get their news. That's scary. That's a little scary. Okay. So you'll be surprised what you find out there for jurors, ladies and gentlemen. You'll be surprised. You can always find a juror. Okay. I think I told you once we had big old case. It was multiple. It was like doomsdayers. The world's coming to an end, and all of a sudden, the children are dead, and like they're found like mummified on the property, and everyone's like, I don't know. We were all too. My kids are fine. I don't know what her kids are, right? But once we found them dead, we just put a tarp over, right? It's no big deal. It's kind of a big deal. It's in the press. It's international. I was getting calls literally from all over the world. Probably because it was like, well, is it voodoo? Is it some sort of witchcraft? I mean, weird stuff, right? I'm like, Judge, we need to move this out of here. And she agreed to move it out of a small county into a little bit bigger county within her judicial district. I'm like, I don't know, Judge. 600 jurors isn't going to be enough. Think everybody's heard about it. We got like halfway through the first 300. Yeah, I think we're going to be okay, Judge. I think we'll save everybody the trip in because people live under rocks for most of the time. Okay. So for those that are interested in it, let us have a look at everything. Okay. My hat is off to Lori Hellis. She's done a great job, and I look forward to the judge having to rule on her motions. I guess we'll have to wait and see whether he comes up with something else, like, I don't know. I think that font seems a little large, not prescribed under the local rules. Reject that. Now you may say, "Oh, Scott. Who would argue over font?" Oh, it is true, ladies and gentlemen. You have to use the right font. Not so much in district court as it is in you file a brief with the Federal Court of Appeals or file a writ of certiorari with the Supreme Court. You have to do it. I mean, right font, margins, index has to be just right. Citation of cases has to be statement. If it's not done, reject it. Form over substance, ladies and gentlemen. But yet, if you're a pro se defendant, you can scribble it on a piece of paper and say, I appeal. I need an attorney so I can appeal. Fine, give him an attorney. Gideon V. Wainwright literally wrote a piece of paper saying, Judge, I want a lawyer. They won't let me have a lawyer. And it became that if you're indigent and they want to send you to jail, they being the government, they have to provide you an attorney if you're in custody or you're indigent. So that's good. So, all right. Can you believe it's already that time? I got talking. I told Frank, hey, we're going to throw in a couple of those commercials tonight. But I wasn't going to do it. I was just talking. He was holding up a sign over here. Scott, hard break. You got to pay the bills. You got to pay my salary, Scott. Come on. I didn't do it. It's almost like a Patreon show in that regard. And we didn't even take any questions. I didn't even see. Were there any, we don't ask for super chats, but sometimes people give super chats. But I was just kind of on a roll tonight. So we just kept going. But anyway, we have to go so that we can go do our Patreon show. So if you haven't become a Patreon, now would be a good time to do it. I think you can get in for, was it like $5 or something? And you get to take calls and we can talk about what we're talking about, not just me talking. And then we have, there it is. The other way. We'll do the Magic 8 Ball. We've got the old school Magic 8 Ball. And here we got the high-speed, low-drag Magic 8 Ball that we used as a replacement. But frankly, I think we get better results. But I don't think the Magic 8 Ball has really ever been wrong. Larry Woodcock, grandparent to JJ there. Yes, there is a hearing scheduled for, I think it's 9:30 tomorrow, Frank? Yeah, 9 o'clock. Sorry, 9 o'clock. But it's going to be in secret. Yep, that's right. Public, you don't have a right to know. Now, I feel bad for the Woodcocks because my understanding is they're not exactly getting filled in very clearly by the prosecutors as to what is going on. And, if I'm speaking out of school, I hope I'm not, but, the victim's family, and usually they kind of pick like a representative and then stuff disseminates from there to other family members. But normally the victim advocate, there's an assigned victim advocate, where I usually practice in each courtroom, the bigger jurisdictions. And their job is to keep everybody informed, bring the DAs together with the victim's family. What's the status of the case? We're thinking about this. Here's what's going on. Now, do they get involved in every aspect of it? No. But, normally, like we have a Victims' Rights Act here in our state where the family has to be consulted on basically every motion that in a Victims' Rights Act case, usually where there's a victim as a person. If you're accused of, I don't know, theft of public property, you're not going to do something like that. But when it's an assault case, a homicide case, a sexual assault, hey, we want to argue bond. Can't do that until we talk with the victim's family, things of that nature. Usually there's nothing can be done unless there's an offer, has to be at least consulted with. They don't, family members don't have veto power over it, but they have to do that. So hopefully but here, when Mr. Woodcock himself is listening to Scott Reich, and wants to know if there's a hearing tomorrow, it makes you kind of wonder, well, where's the victim advocate? Why are they not being informed? It makes me go, which, if I was a betting man, I'd put money on the prosecution. Okay. They got all the resources. They got all the good facts. They're supposed to be able to prove this case when they charge it, to be able to present to a jury and prove beyond a reasonable doubt. That's usually who, if you're a betting man, you go with the prosecution. They win most of the cases that they bring to trial, but not all of them. And like I said, if the prosecution had to prove this, go to trial on this case, let's say from the time that Chad Daybell entered a plea of not guilty, would they have been ready? Hell, I'm not sure at this point they're going to be ready in 4 months, which brings me to the final point that I'll talk about, and then we'll go, is the whole issue of if Lori Vallow, is maybe she not taking her medications? We know that her attorney had mentioned previously in pleadings that her fragile mental state, basically is changing periodically. And that they have this issue, and then they're going to have an issue regarding basically her competency pursuant to the court's order saying that we're going to talk about that. And that's why we're going to seal it. Does that mean she's going back to, it's not like the judge is going to say, well, Ms. Vallow, the attorneys are quite concerned that maybe you're not taking your medication or something. The judge isn't going to get involved in that. He's going to say, oh, okay, you got it. All right, I'm going to send her. Let's send her back. Does that delay then Chad Daybell? I would say no. But the prosecution has been hell-bent on doing just one trial. And I understand why they only want to do one trial, but the reality of it is that if they have to do 2 trials, so what? Go do 2 trials. That's your job. Frankly, it'll be easier the second time around. You'll fix any problems you had the first time through. Okay. But like I said, we'll find out maybe tomorrow if they decide to let us know. They put an order out in a couple of days. And so, like I said, Lori Hellis doing a great job, which makes me wonder, and I'm not throwing stones, but where's the press on this? Where are the big boys, the ABCs, the NBCs, the East Idaho News? Why do they not have attorneys saying we want access to all of these records? I don't know. I offered to help Lori, and maybe we'll have to jump in ourselves. Maybe, if it's not just her, maybe it's other people saying, Judge, we're entitled to this, and you should give it to us. And if not, you better explain really well why we're not entitled to it. And then we'll, maybe we'll appeal it. Because First Amendment, freedom of press goes a long way. All right, ladies and gentlemen, I want to thank you all. You're lucky we didn't throw any ads tonight. I guess Frank will just have to work for free. But anyway, we'll throw them in tomorrow, so be prepared for that. We're going to take a 5-minute break, and then we're going to go do our Patreon show. So join us there. Join us there. Go join us on Patreon. Links below.